All right, good evening, folks. Welcome to Monday Night Law. Boy, do I have some good stuff to share with you tonight. For some, for most, I think. Today we had a hearing for Casey Baker, preliminary hearing. And this was based off of what happened down at the Ada County Courthouse on March 15th. It has been alleged that and been charged with a public offense under the Idaho Code for battery on a police officer. Oh, really? Having a hard time playing the video. Let me do a refresh here on Facebook. Okay, now we're back. And the comments are working again. Yay. Hi, Bobby. How's it going? Hi, Diesel D's. What's up, brother? Olive Lucas, Tabby, how you doing? So I'll be playing those video clips here shortly. But I want to give a shout out to my team and those behind the scenes and everybody that's working very hard to put this together. What we're the ultimate takedown, and it's coming, folks. I'm telling you. Make no mistake. This stuff is going to get taken down. That's actually what I was referring to there, Villavalalo, about the 64-page LAFA notification letter. Yeah. So I want to thank all my supporters and followers out there, you subscribers on YouTube. And I noticed that some people have been automatically unsubscribed from YouTube. So those of you that had previously subscribed, you might want to check your subscription to my channel. You may have been arbitrarily unsubscribed, not by my own doing, but some random algorithm over there unsubscribing people. So, and I want to thank everybody who's supported. And I know that PayPal and Cash App are down now. I can't. I'm basically banned from them. So, because that thing that I talked about that we're not supposed to talk about, and we can't disagree with any public servant out there. We can't say anything contrary to what their opinion is and what they're putting out. But so I just want to thank everybody that has sent their donations and stuff over to the office. And again, the office address if you'd like to help support the channels and keep things going here. Over to the office there at 6477 West Fairview Avenue, Suite C, Charlie, Boise, Idaho 83704. So being posted out here on YouTube. And if you're on Facebook and watching here, that address is right there on the channel itself on my Facebook page. So if you need that, it's there too. And I'm not real sure about crypto yet. I'm not saying it's a bad thing, and I thought about doing that stuff a long time ago, but I've just never dove into it, and I'm not very knowledgeable on it. So I'm the kind of guy that likes to do a little bit of research and, be fully informed before I jump into something like cryptocurrency. So not that I'm against it at all. I know a few people that do it and have been successful at it. So I'm just not there yet. So, but one of these days, maybe we'll see. All right. So with no further ado, Now I'm going to have to pull, let's see which one. This is the first one. Let's see what happens here. Now the audio is a little scratchy here because whoever this is here, I'm not sharing yet, so, but we'll get here. So bear with me as this was previously recorded, and I'm playing this for you folks. All right. That one goes to 4. So, oh, I'm already on 2 on this one, so we're already good over here. Okay. Now, I'm going to find this spot where we were talking. All right, here we go.
Mr. Judd, any indication that I'm all right, and it looks like, let's see, Mr. Baker on the line? No.
Yes, I'm here.
Oh, you are, okay. Head right over to Casey Jack Baker, CR01-21-0889. Mr. Baker, you can hear me okay?
Yes, I can.
All right. So I see your name on the screen, and the video just really seems to be lagging for some reason. So maybe it might help if you just temporarily deactivate the video. It's hard to tell, but I just want to make sure that we can hear it. All right. So your video seems to be turned off. Mr. Baker, can you hear me okay?
Yes.
All right. This is the date and time that's been scheduled for the preliminary hearing of a felony charge of battling on a enforcement officer. Yeah.
Yeah. This video here, I know it was going, and that's what that noise is in the background. So I apologize. I don't have any control over that noise. It's almost like they did it on purpose. But bear with it and see what you can hear here.
2 counts for that. First of all, is this party represented by a lawyer? According to my standards, we do not have a lawyer.
Your Honor, I am objecting to personal jurisdiction as well as the subject matter jurisdiction, and I have chosen assistance of counsel. Thank you.
All right. Well, your objections have been noted. Could counsel identify himself or herself for the record, please?
My name is Kirk Pendergrass.
Can you spell your last name, please?
Pendergrass.
All right. And I'm sorry, Mr. Pendergrass, not familiar with you. To be clear, you're admitted to practice law in the state of Idaho?
I don't seek permission to exercise the right, Your Honor.
Oh, okay. So you're not a lawyer?
I am a lawyer. I'm very knowledgeable on the law, and I speak the law. I am a law sayer, yes. I am not a member
Did you go to law school?
club known as the bar.
Oh, okay. You faded out on me. It just made it sound like you said you're not admitted to the Idaho bar. Is that true?
I'm not a member of your club, no.
Okay. Well, I think that makes it illegal for you to give legal advice to others.
What lawful authority? Can you cite the law on that?
In hearings like this. So, what I'll do, Mr. Baker, is simply defer to you. I will consider you to be unrepresented by counsel. What I want to make sure that you understand, Mr. Baker, is that if you cannot afford a lawyer, I would certainly consider hiring counsel to represent you in public respect rather than appointing counsel to represent you. Would you like
No,
to-
thank you.
Sir, making false statements is a felony.
All right, Mr. Pendergrass, I'll just ask you to remain silent for the
A
remainder
man
of
named Christopher Hallett, CEO of E-Clause, back in 2017, we went to Congress and we challenged the bar as a monopoly, and you can't license the practice of law. This is how E-clause got created as loss prevention for the government of the United States of America under the consent of Congress.
All right, Mr. Baker, I'm going to continue further proceedings in your case for an evidentiary hearing today at 1:30.
I'm going to object to that, and I'm bearing witness to your usurpation of power and your fraud.
Stay ready for hearing today.
Your Honor, I am ready for hearing today. I don't know how the court wants to do this. I don't have a way to get Mr. Baker documents, but I'm only going to go forward on one count of battery on law enforcement instead of the 2 counts. I don't think there's a really good reason to separate it into 2 counts. I can file an amended complaint, but I would just need a way to get it to Mr. Baker, or I can just go forward with one.
All right. If you would prepare an amended complaint for me, please file that at your earliest convenience. Mr. Baker, I'd like to get you a copy of that so you can read it before the hearing. Do you want to give us a way that we can get you that hearing or get you that document?
We're going to object to this. This court is not a competent court. This is a fraudulent court. This is a de facto kangaroo court. It has no lawful authority in America.
A de facto kangaroo court? There is no...
Sure, you're quite aware of those terms, right? You did go to law school. Did you pass?
All right, Mr. Pendergrass, you are excused. Mr. Baker, I will see you back at 1:30. If you ever change your mind about wanting to see a copy of the charging document against you, just reach out to Mr. Judd. He'll be
We'll object to that. Insufficiency of service, insufficiency.
See you at 1:30. State of Idaho versus Sean Ray Martin.
All right, so that's the first one. Now, we had to wait and wait and wait for the good one. Okay, this is the good one.
Okay. And Mr. Pendergrass, you mentioned to me earlier today that you might want to advocate on behalf of Council Mr. Baker. Is that still your intent today?
Yes, sir.
Okay. Now, I'm just going by my memory here, so correct me if I'm wrong. But you told me that you were not admitted to practice law in the state of Idaho. Is that right?
Admitted by who?
The Idaho State Bar.
The Idaho State Bar doesn't issue licenses.
Okay, so I'm right.
Operation.
Not admitted to practice law in Idaho.
I'm going to put you on judicial notice. Founders Constitution, Volume 5. This would be page 246, Section 2. The Body of Liberties of the Massachusetts Colonies in New England, 1641. Every man that findeth himself unfit to plead his own cause in any court shall have liberty to employ any man against whom the court doeth not accept, to help him, provided he give him no fee or reward for his pains.
All right, well, Mr. Pendergrass, I'm going to infer from the fact that you're citing a law from Massachusetts in 1652 that you did not go to law school and that you're not admitted to practice law in Idaho. Now, I could be wrong. Either way, you haven't filed a notice of appearance in this case. So what I'm going to do is politely ask you to be quiet. I'm going to talk directly.
I'm going to object to your usurpation of power, your scheme, scam, and fraud you're running here. You're actively engaged in human trafficking, involved in serious human rights violations, human trafficking, and corruption. I've recently discovered the fraud of these unlawfully created courts. You're acting under the Code of Civil Procedure from statutory law of the United Kingdom, Title 1, Chapter 1, Subsection 101, courts enumerated in your Idaho Code, which is not law. See Peterson versus Peterson, Idaho Supreme Court, 2014, Judge Eisman. The Idaho Code is not the law. Now, what we got going on here is a bunch of esquires holding the title of nobility who have invaded our land, subverted our law, overthrown our Republican form of government, and are actively engaged in human trafficking. Your court, under Section 17 of the United Kingdom's statutory law from 1881, subsection 17 there, is the High Court of Admiralty of England. So I'm going to take serious exception to the lawful creation of this enumerated court under the Idaho Code, which is nothing but bar code And it's not law. You're subverting the law, and you're all actively engaged in human trafficking. And I'm here to bear witness and tell you and inform you I am doing an audit here, and I will be reporting to who I need to report to.
Thank you, Mr. Pendergrass. Your objection is overruled, and I would ask you to refrain from interrupting the proceedings anymore. Otherwise, you may be deemed to be held in contempt of court. So what I'm going to do is just direct all of my comments to Mr. Baker. If you'll just sit back, you're certainly free to sit there, but I just ask you to stay quiet.
Okay,
Mr. Baker.
ask all you want, but the problem is you have no lawful authority to do what you're doing right now. And I'm accusing you of the crime of
Now, Mr.
engaged
Baker,
in serious human rights violations, human trafficking,
hold on one
corruption.
second, Mr. Baker.
This court does not have lawful authority to exist in America.
Mr. Baker, you're facing potentially 5 years in prison. You submitted an application for court-appointed counsel, but you didn't fill it out. So let me ask you, as opposed to Mr. Pendergrass, would you like to be represented by a lawyer in the case?
If you're referring to a lawyer as a member of the bar, why would I want to be involved in anything doing with that snake pit of human traffickers?
Oh, because the information I have makes it look like you're 69 and you're
I
facing
am.
a 5-year felony sentence. And your case may not go to trial until you're 70. And if you're convicted, you could be ordered to go to prison for 5 years. And my guess is probably around the time you turn 74, you'll wish you made a different decision on May 3rd, 2021.
So are you threatening this man, sir? Are you threatening this man?
Mr. Pendergrass,
Force and violence?
A contempt charge.
Under
So let me just ask
authority,
Mr.
you don't
Baker-
have any lawful authority to sit there. You're impersonating a public servant.
I know a lot of people say that, but it's true. I'm an actual judge.
You
Now,
are.
Mr. Pendergrass,
Under the High Court of Admiralty of England? Because not in our republic. I've studied the Organic Act for the territory of Idaho, and I'm not
Mr. Baker.
of this
Sorry,
jurisdiction in America.
Sorry to interrupt. I'm going to talk to the defendant if you don't mind. Mr. Baker, did you want to be represented by a lawyer? Yes or no?
No.
All right. What would you like to do today? Your case is on track for a hearing, and we can do that today. But if we proceed to hearing, you'll have to represent yourself. I'm not going to let Mr. Pendergrass do it.
That's not for you to
I
decide.
have the right to assistance of counsel, that you cannot deny my liberty and right to assistance of counsel.
All right. Mr. Baker, I'm going to postpone your case to a later date and time when I can talk to you without being unreasonably interrupted. Let me find another court date, and I'll put you on the calendar for that day, and I'll see you back at that time, okay? Let's put
Now
it on
watch
the-
this.
the next available date.
Be advised, treason is a capital offense.
Mr. Prosecutor sitting there with this smug smile on his face. This is the bar for you, folks. They think they're above the law, that they can't be held accountable, that they're not doing anything wrong, and they just play the game of we're going to do what we want to do and catch me if you can.
What day is that? All right, May 20th at 1 o'clock, Mr. Baker. Can you reappear on that date and time?
What day of the week is it?
Thursday?
I believe we can do that.
Mr. Judge, does that work for the state and its witnesses?
Your Honor, can I just check with Deputy Mulkey, who's on here, if he's available that day?
Sure.
I'm in a week-long training class from the 17th to the 21st. If need be, I can break it for the hearing.
Well, let's do this. Why don't we just schedule it for a status conference, May 20th at 1:30. And Mr. Baker, I'll see you back at that time. There will not be a hearing that day because the state's witness is unavailable. I'd like to try and get a different date for you when you can appear on my calendar, but just due to the vagaries of all of my different responsibilities, I'm not able to accommodate you on any date besides May 17th or May 20th. And most of June is unavailable, and our calendar doesn't quite go out as far as we need to. So on the 20th, Thursday, May 20th, at 1:30, I'll direct you to be present by WebEx or Zoom or whatever virtual platform we're using that day. And we can cover a little bit more groundwork on that date. But to be clear, the state is not obligated to send out subpoenas for that day, so there will not be a hearing. We can try and make good use of the hearing, though. We can talk about your rights, your options, we can talk about counsel, maybe if we do have a lawyer, if we filed a notice of appearance, we can talk about that. We can talk about the status of discovery and those kinds of things, because, as I said, I want to make sure that your rights, like rightful, under Idaho Criminal Rule 16 are being taken care of. So, Mr. Baker, can you reappear on that day, at that time, May 20th, 1:30 p.m.?
Yes.
All right, and we'll send out a link to you through the trial court administrator's office. Let me just make sure that we have a good mailing address for you so that you actually get the information. Do you still receive your mail at the address on Powell Avenue in Colorado?
No, I do not.
Do you feel comfortable giving me your new address now, or would you like to update the clerk in a more private style?
I'd like to do it in a more private way.
All right. So here's a phone number for you if you want to make a note of it. It's 208-287-6900. That's the phone number for the Ada County Court Clerk. And you can tell whoever answers the phone what your new mailing address is. And the reason why that's important is because they're one of the last organizations on earth to communicate exclusively through the mail. And when they send out a letter with the court date and the link and the information and all that, I just really want to make sure it's clear. Okay?
Right.
All right. Mr. Judd, anything else the state wants to put on the record today?
No, thank you, Your Honor.
Okay. Mr. Pendergrass. Well, let's do this. Mr. Baker, do you have any other questions for me?
No.
Oh, thank you. You are excused, or you can say whatever you prefer to do, Mr. Baker. Mr. Pendergrass, can you tell me if you intend to show up on May 20th at 1:30 and attempt to represent Mr. Baker?
I'm going to object to your use of words, and I don't answer your questions. So where does your lawful authority to exist come from? This court that you're operating right now.
All right. Well, Mr. Pendergrass, what I want to do is advise you of a couple of things, because I'm worried that not only will Mr. Baker's rights and freedom be compromised by the choices that he's making, but I'm concerned that your rights and your liberty might be compromised by the choices that you're making. One of the things that you should be aware of, if you're not already, is that the practice of law in Idaho without a license is a misdemeanor. You could be criminally charged for that.
Okay.
Now, the practice
Law would that
of
be?
law- The practice of law is something.
Cite the lawful authority on that, please. What's the law you're citing? You're threatening me with force and violence here. So what law are you citing?
Well, I'm not sure that I'm threatening you with force or violence, but I see what you're saying. So to answer your question, and frankly, based on what you've told me about yourself, I'm surprised you're not aware of it already. But you might want to take a look at Idaho Code Section 3-401 and 3-420.
So you're citing the Idaho Code as law? And that's your authority? That's your authority to threaten me that I have to have a license to practice law? You're going to charge me with a misdemeanor, which would be a bill of pains and penalties?
I'm not charging you with
Strictly
anything.
prohibited in Article 1, Section 9 and 10, both state and federal. You know that, right? So be advised, sir.
All right, Mr.
You
Pendergrass.
are committing several felonies. You've made threats of violence
You don't stop
against
calling.
me.
Just the call. All right.
Do you think you have a right to a cause of action against me? By all means, follow due process of law. File the proper paperwork. I will properly respond to you. But make no mistake, I am doing part of what I do as my business. Okay? I previously worked for E-Clause, like I explained to you earlier. Christopher Hallett went to Congress and challenged the bar's monopoly and the fact that you cannot license the practice of law. It doesn't exist. Your membership card to the bar is not a license to practice law. So what we have here is a situation where we have a confidence man, confidence game, and confidence trickery, a scheme, scam, and fraud of the bar. We've been at war with the bar for I don't know how long, clear back to the War of 1812, when we tried to ratify the original Article the 13th, because they are articles in addition to, not amendments, as a copy of the Bill of Rights that I have sitting right here. They are articles in addition to an amendment, not amendments. So with the Construction Acts of 1871 and then the creation of the American Bar Association in 1878, you fundamentally altered our form of republican form of government and turned us back into a monarchy, invaded us, and you're actually engaged in domestic violence. You're human.
All right, Mr. Pass, I'm just going to politely ask you to give Mr. Judd a word in edgewise here. Mr. Judd, you were saying?
Your Honor, I feel like this may be a hearing that if Mr. Baker's willing to wear a mask, that would be better to do in person. Thank you.
Well, let's talk about this. We've already scheduled further proceedings for a different date and time. I'm not prepared at this point to entertain a motion to have an in-person hearing. But Mr. Pendergrast, I think we're just about done. Before we wrap it up, do you want me to go over with you the rights that you would have if you're accused of a misdemeanor?
You're going to inform me of my rights.
If you want me to.
Advised, ignorance of the law is no excuse, and the maximal laws to know a thing and to be bound to know it are regarded in law as equivalent. Are you bound by Article Clause 3 of the Constitution of the United States of America, 1789, sir?
We're going to go off the record and the court's in recess.
So, I clearly didn't want to answer the pertinent questions, such as, can you cite the law? Because, see, they can only practice their bar code. They can only practice the Idaho Code under the admiralty jurisdiction of the High Courts of Admiralty of England, because that's the only body of law they can practice. And like I explained to them, that I'm aware that, through the Reconstruction Acts of 1871, the creation of the bar and American Bar Association in 1878, that you've essentially you've invaded us and hijacked our form of government. So there's no excuse for him to not know, but he would not answer the question if he was bound by the Constitution, pursuant to Article 6, Clause 3. So, if you, for the very beginning there, you saw that sheriff deputy in there watching, they were trying to set me up. Well, are you admitting that you're practicing law without being admitted to practice law? Because that would be a crime, right? According to the bar code. And like I informed him, I'm not here to answer your questions. And I don't like his choice of words because it's a setup. So the thing is they are acting under the statutory law, and I'm going to show this to you again. Kill the sound here. So here's their Idaho Code, which we know code, C-O-D-E, is not law, L-A-W. But here's the Idaho Code. This is the very first thing in the Idaho Code. Title 1, Chapter 1, Subsection 101. The very, very beginning basically the first page of the Idaho Code. Enumeration of courts. So they're saying that the courts of justice of this state, the Supreme Court, Court of Appeals, district courts, and the magistrate division of the district courts. The history of this starts with CCP of 1881, Section 17. Now, this is, again, I've showed this before now, this second time, that I went down the rabbit hole. I'm like, what the heck is the CCP? Is this the, the Communist Chinese Party? Or the Chinese Communist Party from 1881? Or, what's going on here? But see, this is how we do research, right? So we look at this and we go, well, wait, this is the Civil Procedure Act, statutory law revision. Okay. So this is the Code of Civil Procedure Act of 1881. And it's the statutory law revision. Civil Procedure Act is an act of the Parliament of the United Kingdom. Right there. Now, what is the statutory law of the United Kingdom being used to enumerate our courts here in America, let alone in Idaho? This just does not make logical sense unless you know the history and a history of what they've done. Okay. Now, certain parts of it was repealed in 1989. But it doesn't change the fact that these courts were enumerated under this statutory law, and only certain parts were. So the text of the statute is originally enacted here is right here. And we get down in here to section 18. Should be, where in the heck is it? I think it's right here. We go. Right there. Section 17 and 18. This one's 17, right? An act to appoint persons to administer oaths and to substitute stamps in lieu of fees and for other purposes in the High Court of Admiralty of England, in part, namely, Section 5, blah, 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 blah. So, what are they acting under here? That would be the Court of Admiralty of England. Now, here's 28 USC, United States Code 454, practice of law by justices and judges. Any justice or judge appointed under the authority of the United States who engages in the practice of law is guilty of a high misdemeanor. So essentially, that's what he was doing. He was practicing law from the bench. That would be an unauthorized practice of law. Now, let's go back through a little bit of history here. Let's see. This is Article 9. I believe this is the Pennsylvania. Yep. Pennsylvania Constitution. And actually, this is the Declaration of Rights of the inhabitants of the Commonwealth or state of Pennsylvania. Now, I've showed this before, but that in all prosecutions of criminal offenses, a man hath the right to be heard by himself and his counsel. This is a right. This is a right retained by the people. Period. Okay, so we know that this is a right enumerated throughout history, all the way up to the Article the 6th of the Bill of Rights, the right to the assistance of counsel. The Bill of Rights is not the the only Bill of Rights that are out there. So here it is. This is in America at the time of 1776, September 28th, 1776. You know, fundamental principles here that all men are born equally free and independent, have certain natural, inherent, and inalienable rights, among which are the enjoying and defending life and liberty. Maxim of law here: what a man does in his defense is to be considered legal. Okay? So, you know, we just these basic fundamental principles of law, real law. There's no code here. Okay? So let's go on to another one. Yeah, I love this one because this is the Constitution of South Carolina, March 26, 1776. Let's see, therefore, severally remonstrated against the passing and petition for repeal of those acts, but in vain, and whereas the said claim being persisted in, other unconstitutional, anal oppressive statutes have been since enacted, by which the powers of admiralty courts in the colonies are extended beyond their ancient limits, and jurisdiction is given to such courts in cases similar to those which in Great Britain are triable by jury. So, you know, we have to know this stuff because we're not going to be able to take it down without this knowledge. Remember, knowledge is power. Got to have this knowledge, which will literally empower us. But let's take a look at another one here. Oh, wait. I already had it. Maybe it was this one. Oh, yeah, there's this one. That a frequent reoccurrence to fundamental principles and a firm adherence to justice, moderation, temperance, industry, and frugality are absolutely necessary to preserve the blessings of liberty and keep a government free. The people ought therefore to pay particular attention to these points in the choice of officers and representatives, and have a right to exact a due and constant regard to them from their legislatures and magistrates in the making and executing such laws as are necessary for the good government of the state. For government. Limited jurisdiction here over the government, not over the people. There's one. Dang it. Where did it go? Maybe it was the Delaware one. No, it wasn't the Delaware one. No, it wasn't that one. Where did it go? I did have it pulled up, I thought. Here you go, Brian. That the freedom of the press is one of the great bulwarks of liberty and therefore ought never to be restrained. How about this one? That every free man, restrained of his liberty, is entitled to a remedy to inquire into the lawfulness thereof, and to remove the same if unlawful, and that such remedy ought not be denied or delayed. Period. I was inquiring into the lawfulness of everything, and all he kept citing was the Idaho Code. But the Idaho Code is not law. That no free man ought to be taken, imprisoned, or diseased of his freehold liberties or privileges, or outlawed or exiled, or in any manner destroyed or deprived of his life, liberty, or property, but by the law of the land. He kept citing the Idaho Code. How about this one? That no free man shall be put to answer any criminal charge but by indictment, presentment, or impeachment. They're doing these information. Oh, did you get the information? This is prosecutions by information. This goes back to the same crap that was going on in 1776, which the sixth article, the Sixth Amendment, prohibits. You have to have a grand jury indictment for any felony or infamous crime. Period. That's what it says. As it is written. When you read it, that's what it says. And a lot of people have a hard time with that. All criminal prosecutors shall enjoy the right to a speedy and public trial. Public, in the general public, open to the general public, not hiding in a meeting. By an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of accusation. Actually, it's the fifth one, isn't it? Let's see. Right there. Oh, yeah. And to have the assistance of counsel for his defense. It does not say we have the right to be represented by a member of the bar. That's not what it says. Pardon me. I guess it's the fifth. There it is. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. But that's what it says, right? As it is written, when you read it, that's what it says. So why are they doing prosecutions by information? Because that's the monarchy. That's how they do it. Now, back to this one over here, because there's a couple of them. And I know I had it pulled up. I don't think it was Georgia. No, wasn't that one. Maybe it was Maryland. Was talking about the courts of admiralty. Dang it. Or maybe, wait a minute, maybe it was Pennsylvania's. No, no, it's not. No. Dang it. Did I look at New Jersey? Okay, it's not New Jersey. Dang it. I know it wasn't New York I was looking at. It was Article the 13th, too. Or, no, it was 20. That's right. There it is. There it is. That the jurisdiction of the Court of Admiralty be confined to maritime causes. Because they kept extending admiralty jurisdiction onto the land beyond its ancient limits. Plain and simple. I mean, it's in our history. Them unconstitutional, anal, oppressive statutes extending admiralty jurisdiction beyond its ancient limits. This is the same problem we've had in history over and over again. So this is what we're dealing with, right? Let's see. When we look at things like the organic law for the territory of Idaho, the first publication here for the territory of Idaho in the first legislative session for the territory of Idaho, where the Constitution of the United States of America was published in here, we see the Bill of Rights here, and those are listed as Article 1, Article 2, Article 3, Article 4, Article 5. This is 1863, 1864. So this gives you an idea of a timeline of when they changed our Bill of Rights from articles in addition to an amendment to the Constitution of the United States of America into amendments, because they can't directly copy these documents because that would be a fraud. Now, what the heck is going on here? Why is it capturing that? That's some weird stuff. Okay, there we go. So now you can see this a little bit better. That it's, showing that it's articles, not amendments. What happened? How did that change? Why did it change? But then, I just want to show that here. Okay, here's the Organic Act of the Territory of Idaho. Okay, 1863. They show that. Oh. And again, this is Organic Act. This is the organic law. This is the law of creation. Okay. And when we get down in here to section 9, right here, and be it further enacted that the judicial power of the said territory shall be vested in a Supreme Court, district courts, probate courts, and justices of the peace. Where does it say magistrate division of the district court? And where are the justices of the peace? Uh-oh. Which is why I said what I said, is that we've been invaded by the bar and they have fundamentally altered our Republican form of government and turned us back into a monarchy. So, I mean, it's right here. The Supreme Court shall consist of a Chief Justice and 2 Associate Justices, who shall hold a term at the least a seat of government said territory annually, shall hold their offices during the period of 4 years and until successors shall be appointed. Qualified, the said territory shall be divided into 3 judicial districts, and a district court shall be held in each of said districts by one of the justices of the Supreme Court at such times and places as may be prescribed by law. So the justices of the Supreme Court are the ones that are supposed to be presiding over the district courts. They're supposed to travel around. We're not supposed to have multiple judges or justices. The Organic Act cannot be changed. The Organic Act is the creation and pursuant to Article 4, Section 3, Congress creates the Organic Act. When people of the territory want to become self-governed and have a state of being free and equal, right? Which we already have that right, but we're talking about government being self-governed. You have to petition to Congress pursuant to Article 4, Section 3. And then Congress creates this Organic Act. Hierarchy. This can't be changed. This is the law of creation. There's only one Organic Act for every territory. This is, in fact, the law of creation. It cannot be altered. Period. Now, when we get here down here a little bit, the jurisdiction of the several courts herein provided for, both appellate and original, and that of probate courts and justices of the peace, shall be limited by law, provided that justices of the peace shall not have jurisdiction of any matter in controversy when the title or boundaries of land may be in dispute, or where the debt or some claim shall exceed $100. And, this is an and the said Supreme and District Courts respectively shall possess chancery as well as common law jurisdiction. Where does it say admiralty jurisdiction? There is no admiralty jurisdiction here in the territories. That's Article 3, Section 2. That belongs to Congress and the federal side, the military, the president, the commander-in-chief in those military tribunals. Nowhere in the Organic Act is there a jurisdiction of admiralty here. Nowhere. None. There is no admiralty jurisdiction here. So what's it doing here in the States? So we go down further again. I've showed this before, right? This is the first legislative session for the territory of Idaho. So it's got everything that they made here. This is an act of Congress creating the Office of Survivor. Wait, this is an act of Congress? That's right. Congress is dictating. And look, it says, be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled. Whoops. That's the enabling clause. It has to state this or it's not lawful, like the Idaho Code. None of it talks about be it enacted by the legislature of the territory of Idaho, does it? No, it most certainly does not. That's part of the reasons why the Idaho Code is not the law. But as you can see, Congress is the one that's making the law for the territory here and saying, here's the law. You need to publish this so everybody knows. Everybody can read this and know this. Now we get into, oh no, this is still to appropriate the proceeds of the sales of public lands and to grant preemption rights. Again, this is all coming from Congress, in Congress assembled. Because remember, Article 4, Section 4, they're supposed to guarantee a Republican form of government. This is one of those ways that is supposed to guarantee this Republican form of government. And see, this is where we get them here, because this is where it actually lays down the procedures in relation to courts. Act of Congress regulating the fees, costs, and the judicial expense of the government of the states, territories, and District of Columbia, and for other purposes. Being enacted by Congress, then hereafter before the accounts of the United States marshals, district attorneys, and clerks are presented to the accounting office of the Treasury Department, blah, blah, blah. The accounts of the commissioners of the United States Circuit Court shall be, da, 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 da. This is basically telling them how the courts of the United States are. This is the law being enacted, right? Oh, let's see. Requiring an oath of allegiance and to support the Constitution of the United States to be administered to certain persons in the civil service of the United States. They all have Article 6, Clause 3. They're required to be bound by oath or affirmation. Here's when back then, right? I do solemnly swear or affirm, as the case may be, that I will support, protect, and defend the Constitution and government of the United States against all enemies, whether domestic or foreign, and that I will bear true faith, allegiance, and loyalty to the same. Any ordinance, resolution, or law of any state, convention, or legislature to the contrary notwithstanding. That's Article 6, Clause 2. And further, that I do this with full determination, pledge, and purpose whatsoever. And further, that I will well and faithfully perform all the duties which may be required of me by law. So help me God. Where's that oath of office anymore? To define the pay and emoluments of certain officers of the Army and for other purposes. Gee, I don't know. I'm talking about emoluments here. That was what? 1862. July 17th, 1862. Now, what does this say? Statutes of the Territory of Idaho. Title 1. Chapter 1. Uh-oh. Only the form of civil actions and the parties thereto, to regulate proceedings in civil cases in the courts of justice of the Territory of Idaho. Uh-oh. See, this is what they subverted. There shall be in this territory but one form of civil action for the enforcement or protection of private rights and the redress or prevention of private wrongs, which shall be the same at law and in equity. Uh-oh. In such action, the party complaining shall be known as the plaintiff, and the adverse party is the defendant. When a question of fact not put in issue by the pleadings is to be tried by the jury. An order for the trial may be made stating distinctly and plainly the question of fact to be tried, and such order shall be the only authority necessary for a trial. Every action shall be prosecuted in the name of the real party in interest, except as otherwise provided in this act, but in suits brought by the assignee of an account, unliquidated demand, or the thing in action not arising out of a contract. Not arising out of a contract, the assigner shall not be a witness on behalf of the plaintiff. The executor, administrator, or trustee, or express trust, or a person expressly authorized by statute may sue without joining with him the person or persons for whose benefit the action is prosecuted. Here's one. All persons having an interest in the subject of the action and obtaining the relief demanded may be joined as plaintiffs, except when otherwise provided in this act. Imagine that. Any person may be made a defendant who has or claims an interest in the controversy, adverse to the plaintiff, or who is a necessary party to a complete determination or settlement of the question involved therein. But when we get down here, we keep going here. This is Title 2, the place of trial of civil actions, where subject matter is situated, where cause of action arose, that probable cause thing. Again, reading just has to mean reading. This lays it all out how it's supposed to be done. Okay? which is contrary to the Idaho Code because they're going under the courts of England, under statutory law of England. But when we get down to the criminal, watch this. It's a ways down here, but we're getting there. Hey, there's injunctions. I mean, how it's supposed to work. Writs of attachment. That's after you win. You can do writs of attachment to see, civil asset forfeiture. Come take your stuff. Here's how the trial and judgment's supposed to work. Ooh, how's the jury supposed to be formed? Conduct of the trial, the right to the assistance of counsel there. Where that was that? I just saw that. To the parties or counsel. Doesn't say member of the bar, does it? You won't find bar in here. Come on. Coming up on that criminal. I know it's coming. The execution of it all. It's supposed to be a civilized process when we're talking about the common law. It can still be criminal in nature or civil in nature, but the common law is the civilized process. And when we talk about the criminal law, that's for public servants because it's a public offense, which we'll see right here in the statutes for the territory of Idaho, right in the very beginning here. We can never get there. There's for foreclosures and mortgages. Imagine that. Property. But this is still all under civil practice. Oh, what's this? Actions for the usurpation of an office or franchise? Action to be brought by district attorney. Complaint. What to state? Defendant may be arrested. Judgment. How rendered? When person alleged to be entitled may enter an office. Damages recoverable. Rights of several may be tried in one action. Judgment when defendant has intruded into office. I mean, this is still under the civil practice. They got appeals. It just lays this all out. I should mark the number on this. Maybe I did at one point. Oh, wait, there's probate for the probate court. Now you get into those writs of errors. Miscellaneous proceedings. Evidence? I mean, everything's here. I think it was 170. Come on. But see, this is the statutory law, the real statutory law, made it a constitutional convention. You see, we didn't even have a constitution yet in the territory of Idaho. Had to lay down the law first. Writ of mandamus. Civil on contempts and their punishments. Imagine that. I mean, it's all in the civil practice. Wait. Geez, when are we going to get to the criminal? I didn't think the civil stuff was this long. Oh, it even talks about motions, orders, service of papers, and miscellaneous provisions. It's almost like it just keeps starting over, but there's more to it, right? I thought it was 170 something, but I'm at 2. Jeez. Well, they weren't joking around when they wrote this. They covered everything right here. Jeez. Come on. Whoop. Now there's the criminal. Very beginning right here. All right. Yep, that's the end of civil. Then we go into the criminal. What is the definition of a crime? Imagine that we would start out with a definition. A crime or public offense is an act or omission forbidden by law, and to which is annexed on conviction. First is death, second is imprisonment, third is a fine, fourth, removal from office, fifth, disqualification to hold or enjoy any office of honor, trust, or profit under this territory, period. Now, how are we going to remove somebody from office if they're not a public servant? So that would mean a crime being a public offense would only apply to public servants. So again, this is the very first legislative session for the territory of Idaho, 1863, 1864, before we had a constitution. We had to lay down the law first. And that's what this is. These are the statutes being created for the territory of Idaho. And then they made the Constitution. It took 17 legislative sessions to create the statutory law for the territory of Idaho and the Constitution. The Constitution was last, right? So that's what we're looking at right now. Now, this coincides with precisely what the Idaho Constitution actually reads. Article 5, Section 1. For the judicial department, except for forms of actions abolished, the distinctions between actions at law and suits in equity, and the forms of all such actions and suits are hereby prohibited. Right there in the get-go, they just subverted the Organic Act for the territory of Idaho. But I can guarantee you, this particular part was amended. This is not the original. But, and there shall be in this state but one form of action for the enforcement or protection of private rights or the redress of private wrongs, which shall be denominated a civil action. And every action prosecuted by the people of the state as a party. You have to have one of the people as a party. You can't prosecute by information against a person. Like governor is a person in their proper person. Governor is the person. So against a person charged with a public offense. For the punishment of the same shall be termed a criminal action. I just read to you the very beginning of the Criminal Act for the territory of Idaho. A crime is a public offense. Like it says right here, shall be termed a criminal action. Okay? So, that's what I wanted to lay out tonight based on, what I had talked about in the video there in court, in their de facto kangaroo courts, that he just laughed at me that I don't know what I'm talking about when it comes to a de facto kangaroo court. Right. And you're the one that went to law school and I didn't. Okay. Sure. That's the problem. They didn't teach him all of the law. Our schools, again, have been all hijacked, right? A lot of these law schools aren't even under control of the legislature. They're all under control of the bar. They're bar schools. So, much love, everybody. I hope we learned a little bit tonight, and you got to see a little bit of me in action, and we'll see what happens. I'm sure they're plotting and scheming and scamming over there on what to do to stop me, because that one sheriff deputy was in there watching to see if they could entrap me. But your code's not law. And I've already been to the sheriff's office. I've already put you folks on notice. We've already had this discussion. Nope, nope, not China. London, the Vatican, the Roman Catholic Church, the Crown Temple Bar. The International Bar Association is registered out of London. So just so you know. And that's why these are the High Courts of Admiralty of England. It's the same stuff over and over and over again. This isn't the first time in history that they've tried to do this. I've just showed you from 1776 exactly what is going on again today. Okay. So thank you again for your support and your love and your prayers. Obviously, I need more prayers. Pray, get that prayer going. Putting that full armor of God on and hedge of protection. Because these guys are pure evil, man. Right? Sheriff has a job to do. You read their handbook. So did I. It's called dereliction of duty when they don't do their job. They truly believe that they're bound by the code. Well, they probably are under the bar code. But that means that they're all actively engaged in serious human rights violations, human trafficking, and corruption. Period. There's no ifs, ands, or buts about it. You're conspiring with them, you become culpable. Be advised. So we'll call it a night for tonight, and Patreon, we'll see you over there on Wednesday night. And yeah, I ended up taking Friday off again, just to, by the time I even got around to even thinking about, oh crap, it was like 5:45, and I was like, oh crap, are you gonna do the show tonight? I'm like, still at the office. So, and I was actually contemplating on leaving out of town to go camping Friday night, but by the time I got home, I didn't have enough energy to try and load up and go anywhere, so I went Saturday. But yeah, good times with some people I haven't seen for, well, about a year. That time last year. So, all right. Much love, everybody. Thank you all for being here. Thanks for the likes, the follows, the shares, the subscriptions over here on YouTube, and the thumbs up on YouTube. And again, check your subscriptions. See if you've been arbitrarily unsubscribed. And get over on Patreon if you want to be in there for Wednesday night workshop. All right. And thank you all for everybody on Patreon. We'll see you Wednesday night for Wednesday night workshop. All right. Much love, everybody. Have a good night.